pollution. Now, what all the government can do under the Act? The government can set standards for emission, it can regulate a location for the industry, it can relocate an industry or set limits or boundaries where an industry can be established. It can make rules for the management of hazardous wastes. It can make rules for protection of public health and welfare. It can pass orders for the protection of public health and welfare. Provisions provide directions for both public as well as concerned authorities. Now, central government can make rules and or order directions to both the public as well as a concerned authority. For what purposes? The purposes are maintenance of environmental quality, control and reduction of pollution from the sources, that is the pollutant, prohibition, restriction on setting up and or operation of any industrial facility or unit on environmental grounds. Now, what are the penalties mentioned under the Act? First and most important point is that the onus of any contravention which happens under the Act lies on the occupier or the owner of a unit. Now, we've already seen what an occupier means. It has been defined clearly under section 2. Now, according to section 15, 16 and 17, there are certain penalties which have been given. A person contravening provisions. Now, when we talk about person here, it generally means the occupier because the onus lies on the occupier. So, a person contravening the provisions of the Act is liable for punishment in form of imprisonment, which can be a term extending up to 5 years with or without a fine of 1 lakh. If he fails to comply by such measures, a fine of additional 500 rupees, 5,000 rupees per day is imposed on him. Now, even after a year of such non-compliance, if the contravention continues, then the imprisonment term may extend up to 7 years instead of just 5 years. Section 17 clearly states that generally, even though the onus is on the occupier, but it will shift on the head of department or in charge of the unit in case the owner produces enough evidence of his innocence. Now, the chapter which talks about miscellaneous provisions says that any person, even a person from the general public, has the right to move to court in case he finds that there has been any contravention under the provisions of the Act, which is the locus standi, or the right to move to court, has been granted to every person, including the general public. According to section 19, any person, even an ordinary citizen, has the right to approach a court provided he/she has given notice of not less than 60 days of the alleged offence and his intention to make a complaint to the central government or the competent authority. So the locus standi always given to the general public. The only condition which is imposed is that a notice period of 60 days needs to be given, and it has to be given in writing either to the central government or the competent authority of such a complaint, as well as his intent. Now, let's talk about some general case laws. First was T. Damodar Rao versus Special Officer Municipal Corporation of Hyderabad. Now, here the case basically pertained against the municipal corporation for passing construction permits for LIC and IT offices to be built in recreational areas. Now, basically the SC in this case observed that the enjoyment of life and its attainments and fulfillments guaranteed under Article 21 embraces protection and preservation of nature's gifts without which life cannot be enjoyed. So that again it talks about the right to environment, to live in a good and clean environment, to be a part of right to life. Another case would be L.K. Kulwal versus State of Rajasthan, where the problem was of dirty sanitation issues in Jaipur. And again the SC observed that health, preservation of sanitation and environment falls within the ambit of Article 21. Now, under the EPA, it has already been provided that the central government can issue rules and notifications for protection of environment, which the central government has also been doing from time to time. Now, these are some of the notifications under the Act. One could be Doon Valley notification, which was issued in the year 1989, which where it was said that it is prohibited to set up any industry in Doon Valley where daily consumption of coal exceeds 24 million tons. Another such notification is CRZ notification of 1991, where it was prohibited to dump ash or other waste, as well as regulate activities along the coastal stretches. Some other notifications were Dhanu Taluka notification of 1991 and Revanda Creek notification of 1989, Taj Trapezium notification of 1998, where setting up of industrial units was prohibited in certain areas. Now, one of the most important notifications was the EIA notifications, which was issued in the year 1994, which was amended in 1997, and then again issued in the year 2006. Now here, as per the EIA process, environmental clearance from MOEF or the Ministry of Environment is required for certain projects, which are Schedule 1 projects. Some certain projects have been listed under this first schedule of the notification. So all those projects will need an environmental clearance from the ministry. All development projects, whether or not under Schedule 1, if located in fragile regions, also need such clearance. Now, there is a two-stage clearance for site-specific projects, such as pithead thermal plants and valley projects. Now, the first stage when the first stage, which is site clearance, is given, after that the second stage of environmental clearance is only then the second stage of environmental clearance is granted. Public hearing has also been made mandatory to provide transparency to the process of environmental clearance. Now, environmental protection rules were formulated in the year 1986. Now, what it does is lays down procedures for setting up standards of emission or discharge of environmental pollutants. It prescribes parameters for the government for issuing the orders on prohibition of location of operation of industrial units. It lays down procedure for taking samples, investigation, serving notice, submitting samples for analysis, etc. Now, National Environment Appellate Authority was established in the year 1997 under the National Environment Appellate Authority Act. Now, this authority heard the appeals in respect to restriction of areas in which an industrial unit or operation could not carry out or would be allowed to carry out its operation subject to certain safeguards under the EPA. Now, NEAA addressed the cases in which environmental clearance was required, but NEAA has now become defunct after the enactment of National Green Tribunal Act, which established the National Green Tribunals in 2010. Now, these are certain areas of improvement that where EPA could be enhanced and improved. The Act must be followed not just on paper but in spirit. The Act is a very comprehensive Act. It has very good provisions, but The only problem is that it has not been followed in spirit in the country. It is there only on paper. If that very big lacuna is overcome, it is one of the very good legislations we have in the country. Now, also another provision that needs to be made is that we should encourage public participation. Now, governmental authorities and social organizations should help out in public participation by educating the public and local authorities on environmental issues, and they should create awareness through different sources and channels of mass media like TV, radio, newspapers, seminars, print media on environmental protection, and also on how to manage the quality of environment.